there are somehow 10 people living in my client's parents' home. He locked my client out of the marital home, and apparently over the weekend last week has listed the marital home for sale.
Plaintiff is requesting use of a Toyota RAV4.
He was also seen in his mother's red Toyota RAV4, stopping and taking pictures.
She's violating the order currently where she's not taking her parenting time. If she takes her parenting time, she doesn't return the child when she needs to return the child, which I understand are contempt motions.
I've sent people to jail because the mothers did not facilitate parenting time.
You got a 16-year-old who's just said, plain, Dad, I'm not going with you anymore.
Chelsea Vinell versus Trenton Vinell.
Court will note the appearance of Miss Greenley Core on behalf of the plaintiff, Mr. Totes on behalf of the defendant. This matter is before the court on the plaintiff's motion for temporary custody, parenting time support, exclusive use of a vehicle, access to the home as well. And the court will note that Mr. Toth has filed an answer to that motion. And when it's your time to speak, Mr. Toth, I am interested in your answer. You've stated that the parties are now sharing parenting time on an equal time basis. So I'll be interested in hearing when that have started and how it's going. Ms. Greenley Core, you can proceed with your motion.
Your Honor, I'm about to have a coughing fit. Can Mr. Toth go first?
Yes, unless Mr. Toth is going to have a coughing fit too.
No, well, I hope not, Your Honor. So,
Okay.
Your Honor, and I'll direct my argument initially to the statements or the inquiry that the court wants to make now. At the time that the plaintiff left the marital home, which was in May, they did adopt and they were able to coordinate an approximate equal parenting time schedule. The school was still in session at that point in time, and it transitioned to summer. Approximately when the complaint for divorce was filed at that time is where their cooperation, where the plaintiff's cooperation in parenting time stopped, and she unilaterally determined that the child should be almost exclusively with her. That then transitioned after a few weeks back to shared parenting time, which worked well until just a few days ago, where during what was my client's week with the minor child, mom, without telling dad, came and had and took the child from the house. So a court order is necessary, Your Honor, and we still have a few weeks left of summer. And I think that my client's summer week, if you will, would have expired over the weekend, just this past weekend. So if we were to have an order that would reflect some type of week on, week off schedule, this week would be the plaintiff's week with the minor child. But it is going to be absolutely critical that we have an order that would identify a date for exchanges and a time for exchanges, just to make sure that there's going to be every opportunity for the schedule to go as it should. Once the school year starts, Your Honor, my client, who's employed by the railroad, has a schedule that allows him to drop the child off at the bus stop before the school day starts and then pick her up from school at the conclusion of the school day. And he's been able to maintain that. That's consistent with past practice of the parties, Your Honor. So I would note there's really zero allegations contained within the plaintiff's motion that even suggests any of the custody factors. And so there's really absolutely no facts supporting what appears to be a claim for primary physical custody with the old standard Calhoun County parenting time schedule. I would also note, Your Honor, that for whatever reason, the plaintiff's not employed. And if for some reason her claim is that I'm available for the child, well, there's the facts of this case will indicate that she is not independently wealthy. She's not a trust beneficiary. She has worked in the past. At one time, she was a licensed CNA, and she's been gone for 8 weeks, and there is really no reason that she shouldn't have been employed. And I think that factors into the establishment of child support. There's a portion of the motion that's been filed by the plaintiff that my client will make a concession to, and that is the plaintiff is requesting use of a Toyota RAV4. It's clearly a non-marital asset, and my client inherited that from his mother's estate. However, provided that the order would reflect that she will keep the vehicle in its present condition and cause no damage to it, he would be agreeable that she has the use of that vehicle. And the vehicle can be provided to her today.
Thank you. Mr. Toth, I note that when Miss Greenley Clark put in the motion that she had identified that the parenting time was with your client from after work on Saturday through Monday at 6 p.m. Is that what had happened prior to summer and the parenting time being again interrupted?
The information I have from my client, Your Honor, is that up until the approximate time that the complaint was filed, that it was an equal parenting time schedule.
Ms. Greenley Clark, your position.
Thank you, Your Honor. I apologize. I'm having a terrible time with allergies this year. As far as parenting time goes, the parties have never done equal parenting time, so we're not sure where that's coming from. Mr. Vial works, as my motion states, from 6:30 to 2:30, Tuesday through Saturday. The parties have been all over the place with parenting time, and they certainly need an order to follow. The issue is that Mr. Vial has been picking up the child for his parenting time for the times that are specified in my motion and saying, oh, well, I have a babysitter. However, there hasn't been a babysitter there. And the minor child ends up calling my client and saying, well, there's no one here. And she's scared, she's bored, whatever it is, and she has to go pick up the minor child. Mr. Vial works 6:30 a.m. to 2:30 p.m. 6:30 a.m. I don't know what time he thinks the bus leaves, but it certainly doesn't leave before 6:30 a.m. if that's his start time.
I've been told it does, Your Honor. The middle school bus pickup is 6:05 a.m.
If I could continue, Your Honor.
Go ahead.
At this point, it would be reasonable for father to have parenting time on his days off of work. As we've indicated here, it makes sense for him to do that. He doesn't have childcare available. This child is only 11 years old. She shouldn't be left alone during parenting time. So we would be requesting that parenting time would be appropriate from Saturday after work until Monday evening. Now, his parenting time over the last few weeks has been two to 3 days a week, and that's consistent with what we're asking for the remainder of the summer and into the school year. So we believe that joint legal custody and parenting time pursuant to them, what's in my motion here is not only the status quo, but is also appropriate based on the parties' work schedules. It has been alleged in Mr. Vial's response that there are somehow 10 people living in my client's parents' home, which is completely untrue. He apparently called CPS, who came to come check out the situation, finding over only my client's parents, herself, and this minor child living in the home. That was cleared up pretty quickly. So I wanted to make sure that we nipped that in the bud right away. As far as the vehicle, my client hasn't been able to get employment because her vehicle's been missing since Mr. Vial came and took it from her. He can certainly make the argument that that's separate from marital property, but at this point in time, the status quo is that my client was driving that vehicle and should have that vehicle returned. And I think she's open to having that returned. Mr. Vial, as the breadwinner, should be required to maintain insurance, not only for the vehicles of the parties, but also health insurance. I would note that he canceled my client's telephone line. She was forced to get a new telephone line. She doesn't want the old number back because she's already done all of that. But I want to note that because that's important to note that he's already canceling things. So we want to make sure that all of the insurance policies, everything else stays as is pursuant to the status quo during the marriage. So no insurance gets canceled. Additionally, he locked my client out of the marital home, and apparently over the weekend last week has listed the marital home for sale. So at this point in time, we have no objection to the house being listed for sale. However, an order ordering that any proceeds from the sale of the house be put into one of the attorney's trust accounts until we've decided how that's going to be divided would be appropriate. Again, we're not against the house being listed for sale. That's fine. But he really should have had permission from my client. We should have stipulated to what was going to happen with that sale. My client hasn't been in the house since May. She sells all of her personal effects there, everything, and she needs to be able to get in and get those items. So we need to have a specific time when she can access that house to come and get those personal items out. There's also going to be other personal items in there that need to be documented that she needs to get in there. As far as child support, we're asking that go back to the date of filing. We're fine imputing my client to her last employment. That's fine. But parenting time, as I said, should be pursuant to the status quo based on Mr. Vial's time off from his job. This child's too young not to have childcare around, and if mom's available, there's no reason that the child should be sitting alone at his house or with a babysitter at his house. Thank you.
Greenley Clark, what was her last employment rate?
let me see if I have a note here on that. She was last working 2 months ago. Let me see if I have her employment rate here. One moment. I don't have her last employment rate at this time, Your Honor, but I can certainly provide that documentation to Mr. Toth.
Thank you. Anything else?
No, Your Honor.
Okay, Mr.
You're-
Toth, any response?
Yeah, yes, Your Honor. I think I'm perhaps confused because I think what I hear counsel saying is that my client should have parenting time on his days off, which would be Thursday through Monday, but her motion talks about alternate weeks, and I fail to understand why that would make any sense. If he has those days off each week, I see no reason why on a weekly basis, he wouldn't have Thursday, Friday, Saturday, Sunday night, since those are his days off, if that's the basis of the argument. So that would be something that we would agree to if it would be on a weekly basis, Your Honor. We're in summer vacation period, and there's no rational reason why my client shouldn't get what generally everybody else gets. If it's necessary, he can make, the order can indicate that there will be childcare provided for her. Finally, Your Honor, if she's going to go out and get a job, isn't she going to be in exactly the same position that my client is going to be? So this is a situation where allegedly her employment status is temporary. I should note for the record that the issue regarding this non-marital Toyota vehicle came up just 2 weeks ago. She had been gone 6 weeks already and wasn't working. So Your Honor, I see no reason why, if the order is, if we would be agreeable that if we're going to have an order that is going to be each week, we could have the schedule would be Thursday through Monday at 6 p.m. That would be fine. My client is going to be able to get the child to school and going to be able to pick her up. When it comes to the plaintiff, it's nothing but speculation. We have no idea how she's planning on supporting herself. She's going to have to get a job, where she's going to live. There's lots of factual disputes here, Your Honor, but it would seem to me that we could fashion an order that would provide my client on a weekly basis, Thursday through Monday at 6, support. We could utilize, I would agree that we would utilize the income information from the plaintiff's last employment. We would agree that today my client will provide the RAV4 to the plaintiff, and even I'm not sure why she wouldn't be obligated to provide insurance for it, or why she shouldn't be able to, but the order can provide that my client will continue to keep that vehicle insured in the short term. I have no problem with holding the proceeds from any closing of a sale of the real estate in my trust account. And we have no objection to a date being established for the plaintiff to come to retrieve personal property, provided that it's mutually agreed upon that my client can be present when this is going to occur. And so I would think, Your Honor, that given the fact that there has been no evidentiary hearing with the status quo, if you will, that we have regarding employment or lack of employment, the vehicle, her coming to the house and holding the trust proceeds, that an order could be fashioned to reflect that. Absent that, Your Honor, I would think we'd have to have some form of a hearing to try to flush the facts out. Thank you.
Okay. Well, what the court's going to do on a temporary basis, first, obviously, the property is listed apparently at this particular time. If and when the property is sold, the court would order that the proceeds from the sale of that property would be held in a trust account in Mr. Totes' office. Again, with notice of that receipt and that to Miss Greenley Clore, so she has that information available to her. The court would, in this matter, on a temporary basis, appears that parties have been doing some sort of a alternating parenting time. The court is going to grant to the parties temporary joint physical and joint legal custody, with parenting time to the defendant from 6 o'clock p.m. on Thursday to Sunday at 6 o'clock p.m. each week. The other times with the plaintiff. The court will order at this time that, again, continuing through the summer, that it would be in alternating weeks. as is typical of parenting time, and that the parties also have alternating holidays. In this case, do you know who had the child on the 4th of July, Miss Greenley Clore?
I do not offhand. We'd have to ask the parties.
Mr.
My,
Toth?
my client had the child with
She went back.
Okay, then plaintiff would have Memorial Day, Labor Day, and then we would alternate each holiday thereafter.
Changed on the
The
4th.
court would grant the plaintiff the use of the RAV4, which defendant has agreed to, but she would have to maintain the vehicle and keep it in its present condition. The court would order that the defendant would not change or remove any insurance coverage, again, from either the parties, the child, or the vehicles at this particular time. Court would allow the plaintiff to have access to the home to remove clothing and personal items. If the parties cannot agree, then it will occur on July 27, 2024 at 12 o'clock noon. If they agree it on another date, they can do it, but otherwise it'll be on that date. I guess I'll ask Ms. Greenley, Clore, you prepare the order because they're your motions, so you can prepare those and submit under 7-day notice of entry.
I can, Your Honor, just one question, as far as the parenting time goes, for, Mr. Vile works Tuesday through Saturday. Why would he have parenting time on Thursday through Sunday instead of what we proposed in our motion from Saturday when he gets off work until Monday evenings at 6 p.m. So he's
Well,
off work. during
Mr.
the
Toth,
day.
I thought you said he wasn't working on Thursdays.
I work Tuesday through Saturday.
Oh, I'm sorry, Your Honor, I misspoke. So that is correct. So he had, his off days would be, I see. So the order should then reflect that it be Friday at the end of your workday?
Saturday's my Friday.
Okay, so because you don't work Saturday or Sunday.
I work Saturday, not Sunday.
So Sunday and Monday are your days off. So the end of your workday on Saturday through Monday at 6 o'clock each week during the school year.
Okay. Why don't we change that? I just had that written down originally, Mr.
I mean, I
Toth,
can
your
correct
answer.
care.
And then when you stated, I changed it, you changed the days on me. We'll have it
Yeah.
from after his workday on Saturday through
Monday at 6 p.m.
6 o'clock p.m.
Right,
Very
and
good.
is that every week, Your Honor, or alternate weeks?
every week.
And then alternating holidays?
Yes.
Pursuant to
I already said alternating holidays and the alternating weeks in the summer, and the court would again order at this time that the child has to have appropriate child care when the child is in the defendant's care.
Okay. All
Okay,
right, thank you.
thank you.
And Your Honor, could the order also reflect, if we already haven't indicated so, that the plaintiff's income from her last full-time
Yeah.
employment would be
Yeah, I was
utilized?
just going to that. I saw that I hadn't mentioned that. Yes, the support will be set based upon her prior income level in her previous job.
And what's the effective date, Your Honor?
We'll have that the date of the motion, actually service of the day of the motion. So whatever your motion was and serve that it would be 2 days later.
Mr. Toth accepted service last week, however, he's had it for much longer.
Well, we'll take it from last week. I don't know when he had it.
Okay, and then if Mr. Toth could also be ordered to provide his client's income information.
I would think he'd want to do that.
Yeah.
I will do so.
Okay,
Thank you very
thank you.
much.
Court will note the appearance of Ms. Paisno on behalf of the plaintiff and defendant appearing in pro per. This matter is before the court on the plaintiff's motion for custody and supervised parenting time. Ms. Paisno.
Your Honor, thank you. This court has reviewed the pleadings. We're dealing with Isaiah, who's 4 years old. As indicated in my motion, Isaiah has a new diagnosis that will lead to further neurological problems. These parties are unable to communicate about these issues, not only because of the domestic violence, but even prior to that. They had difficulty communicating about what's best for this minor child. In addition to that, stability and consistency are going to be very important for this minor child moving forward due to the fact that with this new diagnosis, he's one of 900 in the world that has this mutation on the gene. So they're still trying to figure out what's going on with that, and it will lead to further appointments and therapists. And when these parties not be able to agree on what's going on for this child, my client believes that it's necessary for him to have sole legal custody. In regards to the supervision, as I indicated in my motion, mom's instability, her inconsistency, her mental health is very up and down. It has been up and down lately. She's violating the order currently where she's not taking her parenting time. If she takes her parenting time, she doesn't return the child when she needs to return the child, which I understand are contempt motions. But her erratic behavior, which causes this minor child to be reactive, and with his autism, his therapy, his OT, mom's inconsistency with that is not in his best interest. So what I'm asking for is this court to set the matter for an evidentiary hearing, so this court can hear the audio, see the video, see what mom does, hear from the police officers whose deals with Miss Reed on a frequent basis for wellness checks. In addition to that, putting this minor child at risk with mom. We don't know where she's staying with the minor child. If it's where she has stayed in the past, there's several animals. There are things that the minor child should not be subject to. That's why we're asking for supervision pending the hearing.
Okay, thank you. Ms. Reed, what's your response?
I have retained counsel this Friday. We did not have time to prepare to address all of the allegations, so my counsel has advised me to adjourn this hearing so that we have time to prepare.
Okay, well, what's gonna happen is I'm not gonna adjourn the hearing, but what I'll do is we will set the matter for an evidentiary hearing. Ms. Reed, have your attorney contact our office so that we can set up a hearing date between he and Ms. Paisno, okay?
Yep, Goldman Associates has told me that they're doing so right now.
Excuse me?
Goldman and Associates, they advised me that that's what they will be doing right now.
Okay,
They'll be, thank you.
okay, good. Well, have them contact us and we will set a court date.
Very good.
Okay, thank you. You're free to go. Have a good day.
Brooke Edwards versus Gregory Edwards.
This matter is before the court today on the plaintiff's motion to show cause for violation of a personal protective order, which she filed on June 7, 2024. Today is the time and place up for the hearing on said motion. In this matter, court has appointed Mr. Sackrider to represent the respondent. Ms. Edwards, at this time, you have a right to make an opening statement if you wish to do so.
I just want to say that I believe that he is in violation of his PPO. He was seen outside of my residence, which is not allowed. He had called police officers, Battle Creek Police Department, several different times, where Officer Ogden called me to let me know that he was in violation. I have the police report number of that. He's just been nonstop. I mean, will not leave me alone.
Okay,
He was also seen in his mother's red Toyota RAV4, stopping and taking pictures. He is also working with Summer McKediac, speaking and talking to her, having her drive by and take pictures. He's having my neighbors check on me, spy on me. I just look for him to leave me alone, sir.
okay. Ma'am, just for clarification, for purpose of this is a hearing for violation by him. So any other third parties, the court's not concerned about any of that unless you can establish that he was in fact the one that instigated and utilized them as in fact an agent of his, okay? So anything else that somebody else might have done that they did on their own or anything of that nature is not germane to this hearing.
Okay.
Mr. Sackrider, do you wish to make an opening statement, or reserve the opening statement, or waive opening statement?
We would waive opening statement, Your Honor.
Okay, thank you. Fine, Miss Edwards, then it's your time to present all of your proofs and evidence in this matter. If you're going to testify, then I'll need to have you sworn in because anything you say is not evidence unless you're sworn in. So,
I mean, just again, Your Honor, I have the police report. An officer contacted me. I was at work. So I do, have her police report stating that he is outside my residence where he shouldn't be and taking photos. I mean, plain and simple. I mean, I got stalking and that he's not supposed to be on my property or my residence. So, I mean, I really don't have much more than that then.
I would object to any hearsay evidence, Your Honor.
okay. What he's doing, he's objecting to anything that the police officer might have stated, which is a valid objection. If you want to have the officers testify, they have to be in person and at this hearing, which presumably you don't have them scheduled to appear at this hearing. Is that correct?
Correct, Your Honor.
Okay. So the court will, grant the motion that is hearsay. And therefore that the report or reference to the report or what the police officer might have said is in fact not admissible at this time. Anything else that you have, Ms. Edwards?
I mean, that's just it, Your Honor. I just, Mr. Edwards would leave me alone.
Okay,
That's all I ask.
okay. With that, I guess, Mr. Sackrider, do you have any motion to make at this time or any evidence?
Yes, Your Honor, at this time, we would move for a directed verdict or a motion to dismiss the alleged show cause violation. We don't believe petitioners met their burden of proof beyond a reasonable doubt. In petitioner's own testimony, she stated that she was not at the residence on the date in question. It's for all those reasons we would ask that the show cause be dismissed. Thank you.
Okay, thank you. Ms. Edwards, do you have any response to the motion to dismiss?
Nope, I just ask that he leaves me alone.
Okay. Well, in the matters when you're a finding of contempt, of criminal contempt, you have to establish beyond a reasonable doubt that the respondent in fact violated the personal protective order. In this matter, you've alleged basically, again, the only thing you alleged was related to hearsay, which is not admissible. And otherwise, you've not produced any admissible evidence in this matter that there was in fact a violation of the order, which was entered on 11/29/2023, effective through 11/29/2024. And as a result, because you have not presented any evidence to establish a violation, the court is going to have to grant Mr. Sackrider's motion to dismiss. I will dismiss the show cause and the petition to hold the defendant respondent in contempt in this matter. I would, however, caution Mr. Edwards. Mr. Edwards, just because I've dismissed this doesn't mean that you have a right to violate the order, that you could be held in contempt of court if properly again established. And if so, then there's a potential that you could have jail time as well, just so. But and what you have to do is do not violate that particular court order. You understand, sir?
Yes, sir.
Okay. That means you cannot basically appear at a workplace residence. You cannot follow the petitioner. And then there are a number of other things in that ex parte order that you cannot do. And so I'm just putting you on notice of that. And then hopefully we don't have to come back in the future. Ma'am, I'll let you know that should there be a violation in the future, you have every right to bring it in at that time. And just simply because we've denied the violation at this time doesn't mean that it prohibits you from filing it any other time. You understand that, ma'am?
Yes, sir. Thank you.
Okay. Both for appearing, and thank you, Mr. Sackrider. You're free to go.
Sade Combs versus Brock Kennedy.
Court will note the appearance of Mr. Carroll on behalf of the plaintiff, Mr. Scott on behalf of defendant. We have two matters before the court. First, the plaintiff's objection to the order submitted by Mr. Scott and plaintiff's motion for change in custody, parenting time support, and requesting a GAL. Go ahead, Mr. Carroll.
Thank you, Judge. I'll cover the objection first. Judge, the only difference between Mr. Scott and my order is essentially that I believe you did order that we get a report from the therapist on or before August 1st of 2024, with the hope that we could have had our hearing set sometime thereafter in August. I think it needs to be in the order for two reasons. One, that's what you said. Two, I think that helps the therapist have an idea on timing, since now it's July 15th, on getting a report available. I believe she's had 6 sessions as of last week, and they usually have weekly sessions.
Well, I think now I was looking in the file. I think isn't our hearing now not until October?
That's correct, Judge. And if you want to change that date, that's fine, but that is correct, October 1st.
Okay. Mr. Scott, what's your position?
Thank you, Your Honor. Your Honor, we were there to show cause order for her to show cause why she should not be held in contempt. There hasn't been anything submitted at all that Brock is doing inappropriate. We have a young lady that doesn't want to necessarily follow the rules and that type of thing, but you did put it out saying that you wanted an evidentiary hearing. And your issue regarding the therapist, there was no motion to order a therapist opinion. There was no motion. You said you wanted to hear from the therapist, but that didn't mean that the therapist would have to do that, number one. Number two, on what scope? On what scope? So it goes beyond the notion of what was being brought before the court. Yeah, you did indicate that there was going to be sometime in August, which I took issue with, given that now we're looking at October, and Mr. Kennedy basically, because the plaintiff has decided that that doesn't have to be followed because this hearing isn't going to happen until October, she hasn't done anything to attempt to have her daughter, other than an alleged encouragement. She hasn't imposed any discipline, nothing on her to follow the order. And now Mr. Brock is sitting with a motion for changing of custody because his 16-year-old daughter apparently doesn't want to go. That isn't how the orders in this state work, Your Honor. I've been the family law chair of the State Bar of Michigan. I've never seen this much time go by on a custody issue when we don't even know what it is with any degree of specificity of what Mr. Kennedy has done. Now, let's have an offer of proof to the court rule that says you got to present an offer of proof, especially with this change of custody, to say, look, at whatever allegation you're going to bring forth, other than this daughter not wanting to go and because she feels that she is not respected or not valued, tell us why. You know, you can't just have that be the rule and then go 6 months without seeing your child when there's a valid court order. So to say that there's going to be a therapist that has to testify in order for this mother to show cause, I think we are giving her tacit authority to say, no, I don't have to follow this order because the judge indicated he wants to hear from the therapist. And I don't think that's what you intended. Yes, you would like to hear from the therapist perhaps, but there was no motion to say, hey, we need to have a therapist before an order to show cause could be heard. So I posed the additional language, Your Honor, added to that because it goes beyond the scope of what the motion was there for or even given any notice to have.
Okay, well, let me clarify that point then. The intent was not that we would put off any hearing or do anything waiting for a therapist. The idea was that where there was a therapist involved, I wanted to get a report from the therapist. So what happens is the fact that I can't have that hearing sooner than we have it in October, I'll extend that out that the therapist would provide a report to the parties in the court no later than September 1, 2024. That in no way does that report impact or supersede or anything as it relates to parenting time. And I'll state, so you're aware of that, Ms. Combs, what happens in this matter, the orders have to be followed regardless of any proceedings that are occurring in this particular matter. And I will tell you, and you have to think about this before that particular hearing, that if in fact the court finds that, again, it is not warranted that you have not taken the necessary action to get the child to appear for the parenting time, you could go to jail. So I want you to be aware of that. And I will tell you, in the last 2 months, I've sent people to jail because the mothers did not facilitate parenting time. So just, you know, and I think it's one of those things that you're going to have some substantial conversations with your child over, because if she is continuing to be resistant and the court doesn't find that there's a basis for it, you may be the one to suffer the consequences.
Judge, would the court just change the date to September 1st on the proposed order that I provided, or do you want another one submitted?
I'd like there to be a separate order. I'd like to have a separate order, Your Honor, because I want to have that order to show cause adjournment clean without then coming back. If it gets challenged or something, Your Honor, the mother says, hey, the judge indicated that he wanted to hear from the therapist.
Okay, I think I clarified that point. I want to hear from the therapist, but I'm not putting that, I was not putting off that hearing until after we heard from the therapist. I just wanted some input. And it was hoped that we'd be able to get the matter in August. We weren't able to in scheduling it. So that's why it was delayed, but it had nothing to do with the therapist report or the continuation of therapy. So with that, Mr. Carroll, why don't you proceed with your motion to change custody?
Thank you, Judge. Judge, and I had as recent as from the therapist report that it's hopeful that she will have a meeting with the defendant and Kelsey I'm hopeful here in the next couple weeks. I know that he has met with a therapist initially to suggest that my client should try to put the screws to her daughter or force her, or I mean, she's done all she can by way of encouragement. And this gentleman comes to the house and Kelsey comes right out and says point blank, Dad, I'm not going with you. Perhaps he should try to have more of a conversation with his daughter, or see or have contact with her at different times. She works at a restaurant. He doesn't go to visit her there. He doesn't ever attempt to text her or have any other contact with her other than showing up on these every other Monday. And when she doesn't go, he then files a show cause, which is, if that's what he wants to do, that's perfectly fine. But then wants to blame everything on mom without showing any efforts to communicate with what's going on with his daughter. He was resistant to the therapy to begin with. Now at least the therapist is going to ask him to come in, which I'm hopeful will be progress as to going on. I know my client did all she could to get her to go on Father's Day, and she came back crying the entire time. What she sees at home with Kelsey's behavior and what the therapist has advised her about Kelsey's behavior during session are concerns. Now, with that being said, since April 8th, Kelsey has not gone. It started at the school. My client wasn't even at the school. She didn't go with stepmom at the school. So I don't know how my client could force her or have some other kind of sanctions imposed on her to get her to go when she chose not to from the school activity event that she was at. And now she openly comes out and sees her dad and says, Dad, I'm not going with you. It's a tough situation all the way around in that regard. Now, we know her concerns, what she's expressed of not feeling loved, feeling treated unfairly in the household. I don't know the full extent of those because I haven't interviewed this young lady. I don't plan to interview this young lady. That's another reason why I thought in our conversation we had on July 3rd that a GAL would be very helpful to everybody, because that's somebody who will actually talk to the child. Of course, the court has the opportunity to speak to her as well, but that ultimately helps us get to the bottom of these things much faster, I think. Certainly there's going to be ample time for a GAL to be appointed. I don't know the three people I recommended. I just know when I called somebody in Calhoun with some names that they provide, and I leave that in the court's discretion. I do think there's more than a significant change in circumstances. When you got a 16-year-old who's just said, plain, Dad, I'm not going with you anymore. I mean, openly right to him. And all this idea that she's is a bad kid or that she's allowed to do all these other things, that's just not true. She is a very good kid who actually works as a babysitter, also has a full-time or kind of a full-time job. They do 40 hours a week. And again, I point to the fact that if my daughter worked at a restaurant and I felt like I needed to have conversations with her or talk to her, I might go and meet her at the restaurant. But I don't see Mr. Kennedy ever make any attempts like that. He doesn't even try to do anything outside of show up at the house on Monday. And then when his daughter says, I'm not going, he doesn't even say, can we at least go for a walk and talk about this? Doesn't do anything. It's either you come with me or else. And the problem is obviously there's a breakdown in their ability to communicate as a parent and child. At 16 years of age, unfortunately, we're not dealing with a little kid. We're dealing with somebody who physically my client can't pick up and move, nor would I ever advise her to, because I'd be afraid what would come out of that situation. So I believe we have more than enough for change. And at this point, Judge, we can almost piggyback it with the same evidentiary hearing on the show cause, which is now set in October. Thank you.
Mr. Scott?
Yes, thank you. I did submit an answer to the motion. I trust the court has seen that.
Yes, I did. I reviewed that.
Yeah, thank you. Your Honor, Mr. Carroll indicates that there's nothing that this mother can do. That is just not true. This mother, if the child did not want to go to school, would impose certain disciplinary measures to ensure that she goes to school. I have not heard one time Mr. Carroll indicating anything other than she can't physically remove this child or assault her to make her go. That said, look, I've taken her phone away. I've taken her car privileges away. I've told her that she can't go see her boyfriend. Any disciplinary measure that would tell this young lady following a court order is more important than necessarily disagreeing with dad. I heard in the motion that she's not feeling loved and she is not treated fairly. Mr. Kennedy simply had issues with her phone use that his daughter didn't like. He also had issues with his daughter being alone with her boyfriend at 16 and going to dorm parties at Michigan State University all the way from Olivet. That was something that was opposed by Dad, and structure had to be put in place. What else has he done? He is willing to talk with his daughter. His daughter, apparently, because this is working for her, is not going to have contact. He would love to have contact with her of any sort. And to suggest that this now rises to the level sufficient to beat an established custodial environment in custody, it simply isn't the case. The case should be dismissed, Your Honor. I put the response, the Curlio versus Curlio decision, where this has happened over and over again. It does become a contest with sometimes policy by certain judges, sometimes policies that are different in terms of how to handle a 16-year-old. But the Court of Appeals has said if the children's changed preference and what they want to do required the grant of a motion for a new trial, the courts would be encouraging the parents to use their children as pawns in this breakup, this marital situation differences between parenting. They should be cooperating as she is ordered to cooperate on Dad's rules. Dad's rules are not unreasonable. A 16-year-old might see not being able to be on her cell phone after 10 p.m. as unreasonable and have a difference with her dad, but that doesn't mean she goes to mom and says, hey, I don't want to go to Dad because you let me use my phone when I want to use it, and Dad doesn't. And so they go on to say, as the Court of Appeals, this situation would place undue emotional pressure on the children and the parents alike. We will do nothing which might encourage immature parents to use their immature offspring in a high stakes game of psychological roulette. Now that's happened here. Now you've got a situation of April, May, June, and half of July, 3.5 months, where with no imposition or no discipline from mom, this 16-year-old is dictating what happens to be the parenting time order of this court. That's bad jurisprudence, plain and simple. And we can't have that situation. Now, if Dad was molesting her, if Dad was beating her, if Dad was doing something, tell us, tell the court that that's what's happening and that intervention is necessary. But here we have a simple parenting dispute when the child is with the other parent. Okay, he has rules that are different. That happens in every family, but that doesn't rise to the level of appointing a GAL, doesn't rise to the level of having a full brand new trial or evidentiary hearing on the best interest standards. That's why the court rule is in place, that I would like to schedule a motion and see an offer of proof. And if this is all that's there, is that she's not feeling loved and she's not treated fairly, that isn't sufficient, Your Honor. So I'd ask that the motion be denied, and certainly there's if it's going to be granted, then we're looking at a substantially more detailed and costly procedure, Your Honor, with custody being mounted because mom doesn't impose any strictures on following this court's order.
Okay, thank you. Anything else, Mr. Carroll?
Judge, I think the court's probably aware that the Curio case is quite distinguished. That dealt with a ruling that the court didn't give a trial for 14 or 16 months. And then during that period of time of that 14 or 16 months, there was the thought that one of the elder children of the three wanted to spend more time with Dad. This is a case that's a 2009. We're not talking about little kids having influence by parents. These folks have been separated since 2009, were never married, and have had a 50-50 in place since 2019 without a little involvement of the court whatsoever. I don't think that's at all what's in this situation here. Thank you.
Okay, thank you. Well, in this particular matter, on a motion for change in custody, the court does not believe that it raises to the level of meeting the Vodvarka threshold. So the court will deny the motion in this matter. I don't see, other than the child's desire that we're hearing through the mother. I don't know if that's the child's desire or not, but it doesn't appear that there's any substantive basis under the Varka threshold to be able to order a hearing. So the court is going to deny that. And I'll ask that Mr. Scott, that you would prepare the order denying the particular motion. As it relates to the request for a GL, the court will grant that. Mr. Carroll, you can do an order appointing a GL and talk to Mr. Scott and see who you can arrive at with the individuals you disclose. Court doesn't have any preference, so it's up to the two of you. The court will make the plaintiff responsible for the cost of the GAL. And you can submit all those orders under 7-day notice of entry.
Thank you, Judge.
Thank you, gentlemen. You're
Thank
free
you.
to go. Have a good day. This matter is before the court on the plaintiff's notice of entry of default judgment of custody and UCSO. Ms. Schulte, are you contesting or disputing anything?
I'm just here to talk for my daughter as her mother.
Okay, that's not what I asked you. I asked, are you disputing or contesting anything in this matter?
Sir, I have no idea what that means. I've never been through this, so can you please elaborate?
Well, you've received the judgment of custody and the UCSO.
Correct.
Are you disputing or challenging that?
Challenging it
Okay, and in what way?
in a good way, because I would
Right.
like,
That's not what I meant, in particular, not generalities or hyperbole.
okay, I guess I don't really know that one. I've never been through this, so I don't really have the correct answer for that.
Well, you said you're contesting it. In what way are you contesting?
In a good way, I don't know.
Okay. Mr. Vanderhorst, maybe you can light me. What's happening?
Okay,
Defendant was personally served on April 10, 2024. She failed to file an answer and was defaulted on May 2nd, 2024. The proposed uniform judgment of custody and uniform child support order have been sent to the defendant court and they were approved on June 28, 2024. Plaintiff is requesting that the court enter the default judgment of custody and the uniform child support order. Defendant mother has not had any parenting time since this case has commenced. So we are asking the court to enter the default judgment of custody due to the failure of the response from the defendant mother. Thank you, Your Honor.
Okay, thank you. Ms. Schulte, anything else that you'd like to say?
no, I do not right now. I'm okay. I'm doing really good. Thank you so much. I appreciate it,
Okay,
Judge.
thank you. Well, the court, based on statements in this matter, was a default entered back on May 2nd, 2024. The defendant has not taken any action to, again, set aside the default or to defend in this particular action, other than, as stated today, to just give generalized objections. In this case, as a result, the court will enter the judgment of custody in the UCSO as submitted by Mr. Vanderhorst in this matter. That will conclude the case. Best of luck to both of you. Ms. Schulte, at some point, I understand, based on what Mr. Vanderhorst has stated, that you've not had parenting time at some point in the future. If you wish to do so, you always have a right to petition the court to seek to have parenting time.
Great. Thank you so much. I
Okay,
appreciate it.
Thank you. You have a good day. You're free to go.
Thank you, Your
Okay.
Honor.
Thank you.
All right.
I have a question. Can you guys hear me?
Yes.
So am I gonna have like any visitation with my daughter, or how does that work?
Well, you'll have to look under the judgment. The judgment will have all the provisions. Mr. Vanderhorst, is there a provision in there at the current time for parenting time?
It states here on the parties shall have parenting time, or the defendant mother shall have parenting time as the parties agree.
Okay. Well, Ms. Schulte, at this point, then you have to try to get an agreement with Mr. Teff. If you're not able to do so, then you have a right to petition the court.
I have a right to petition the court if I cannot get in an agreement with Mr. Taft.
Yes, correct.
Okay.
Court will note the appearance of Ms. Finch on behalf of the front of the court. Front of the court has filed a motion to produce Child Protective Services reports out of Bradley County, Tennessee. They would not produce those apparently without a court order in this matter. I guess I'll ask Mr. Scroggins, are you opposed to them producing the reports?
No, I'm not opposed.
Okay. Mr. Wolf, are you opposed to front of the court acquiring those reports?
No, I am not.
Okay. Well, that sounds easy. The court will grant the motion in order that Bradley County, Tennessee shall produce any and all reports regarding the parties or the children that they have through Child Protective Services or comparable agency down there. Is that what their agency is, Ms. Finch's Child Protective Services?
Yeah, it's Tennessee Department of Children's Services.
Okay. If you could, Ms. Finch, if you could get an order prepared to do that, you can submit under 7-day notice of entry. The court will sign that. Get Mr. Magnuson to help you with that.
I have it ready. I haven't done the 7-day rule in a while, but I'll find one out there because she asked that we put something in there about it being under a protective order.
Okay, that's fine. Whatever, you can do that such that it would only be released, if you want it only released to your office as opposed to the parties, that's fine as well.
Okay, I'll do that.
Okay, thank you. You're free to go. Have a good day. Court will note the appearance of Ms. Paisno on behalf of the defendant. This matter is before the court on the defendant's motion for parenting time and to enforce court orders in this particular matter. The court notes, I guess just from some clarification, Ms. Paisno is originally, I guess, counseling had started with Miss Meredessa Katz, and then there was another individual in Kalamazoo, and then based on what you stated, that the child was seeing somebody at Gray's Health Behavioral Services. Is that accurate?
Your Honor, it's my understanding that Dad has indicated that the minor child was seeing an AVA at Gray's Health, but it's my understanding with my client's discussion with that office that she has never been seen there. I have a letter from that office indicating that the minor child has not been in attendance there.
Okay. Well, go ahead with your motion.
Your Honor, I know the court knows the history of this case, and my client had indicated she had filed motions for custody at the beginning of this year. My conversations with her that it's really not a custody matter right now. It's more of a parenting time and expansion of parenting time. The order allows for parenting time to take place outside of family and children's services if the parties are able to agree on a supervisor. However, they are unable to do so. There have been other counselors involved, such as Katz, that is my understanding, stopped the co-parenting counseling because Mr. Spring refused to cooperate or attend those sessions. I know that the parties worked very briefly with Margaret Hunter before my involvement as well, and that didn't go anywhere, although Ms. Hunter had a plan to try and move things forward with these parties to expand mom's parenting time. I have reviewed the Family and Children's Services records from the supervised visits and things are going well. Mom has been very appropriate. I do believe with the amount of time she's had supervised visits at Family and Children's Services that this court to set this matter for an evidentiary hearing to hear the testimony to expand mom's parenting time to a step-up parenting time to work her into overnights as she works with counselors of her own in order to work on the issues that this court has seen prior, and she's made great progress regarding the same. So I'd ask this court to enter an order either expanding mom's parenting time to make it unsupervised outside of Family and Children's Services, or to set this matter for an evidentiary hearing either before the court or the friend of the court. So the court can make a determination that it is in the best interest of these children to expand mom's parenting time under the parenting time factors.
Okay, thank you. Mr. Spring, what's your response?
Lucy Spring has been seeing a counselor at Avalon Behavioral Health every 3 weeks for the last couple of years, and letters to Miss Parr about where she's going, what her name is. So I don't know why they bring up Gray's. I've never mentioned anything like that. I don't even know what that is. Second of all, I think this should be denied because we were just here in March. The court ruled that the time should not be expanded. Every single time that we go to a counselor, there's always a dispute, and Ms. Parr doesn't want to pay for a supervisor. She doesn't want to work with me on parenting time or visits or anything like that. So that's why the counselor, sessions have been limited, because it's not been successful in any type of agreement.
Okay. Ms. Page, now, do you have any problem with your client, again, participating with Avalon Behavioral Health, where the child's been going for a considerable time?
My client will cooperate with whoever the minor child's counselor is and participating with who she needs to participate with. I don't know the name. I haven't heard that name from my client.
I went to Avalon last month. She said she did not see my children. She only see like once a year, and nothing they can make any process.
Okay, well, what I'm gonna do is I'm gonna order that the children and the parties would be involved in counseling with Avalon Behavioral Health, and that they would contact Avalon within 14 days of today's date to set up appointments so that they can get together. And again, the purpose is for some reintegration counseling or counseling for the children in this matter. The parties are required to participate and to facilitate the counseling. The court is going to, again, allow that counseling to occur for about 90 days. And then after the 90 days, the court will want a report from the counselor. And at that time, once we have the report, then we will set it for an evidentiary hearing. Ms. Paisno, you can prepare the order. You understand what's happening, Mr. Spring?
Yes, sir.
Okay. Contact Avalon, set up a time to have the children seen by them as well as you if they want to see you. I'll leave that up to the counselor. I'm not going to dictate what the counselor has, and then see their mother as well. And then the counselor can work with, again, trying to come up with some sort of a proposed parenting time or reintegration time, if you would, as appropriate based upon the counseling. Okay, thank you. And Ms. Paisno, if you prepare that order, submit on a 7-day notice.
I can do that. Thank you, Your Honor.
Thank you. Have a good day.
I never received any support, nor I can even dig my stuff. So life is just like a nightmare with 2 young kids.
So are you saying that there is no support order at the current time?
The children live with me full time. Miss Parr only sees the children for an hour a week. She pays me child support.
As Mr. Spring states, there's an order requiring you to pay child support, so it wouldn't be appropriate for you to enforce the order because all you have to do is pay the support.